there any interesting stories from your career that you can share? Maybe some, yeah, because I'm always curious when I come across someone who's in the legal profession. I tend to try to get the details, but of course you won't give me confidential information, because as a journalist, always curious, want to know what
this is your chance, Bertrand.
What's the little trick that you use in that? How did you trap them? How did you, yeah, something that you could share with us.
I've been thinking about this, I should say. One always endeavours to settle one's cases if one possibly can, Bertrand. And as I'm sure you know, something like 95% or more of cases settle. Very few cases run to trial, run to what we call run to judgment. Some cases start and then settle. Some cases run to judgment. I was involved in a case which is on the public record, so I can speak of it, which is I've done a lot of sexual harassment matters. 99.9% of those settle. This one is known as the Rivers litigation, and this was a case where my client alleged certain sexual improprieties on the behalf of her boss towards her. And during the course of bringing that litigation to trial, we became aware of two other former employees of the same employer making the same complaint some 5 years and 10 years respectively before my client's employment. Now, sexual harassment cases are always word against word. I said, he said, she said. Sexual harassment's not usually conducted in public, as you might imagine. So when we became aware of these other two complainants, we interviewed them separately from our clients and took what's called a proof of evidence from both of them. And their proofs of evidence were astonishingly similar in the conduct that my client complained about. So we sought and obtained permission from the court to use that evidence from the other two employees to demonstrate the credibility of my client's complaints. Now, this is a technical process. It's very rarely used. It's called similar fact evidence. It's got another name now, but it's essentially called similar fact evidence. It was my view that my client would be believed in any event. She was a very credible young woman, but having obtained this evidence, we thought that we should use it, and similar fact evidence is admitted into the process of the hearing of the matter at the initial stages of the trial. And so that occurred in this instance. So we began this case on the Friday. My client gave evidence. She was cross-examined by counsel for the employer, and then the statements of the other two employees were then put into evidence as documents, and then we went through a process with the court as to whether they would be admitted by reference to the evidence that my client had actually given. And the judge wrote a judgment. This was on a Friday. She wrote the judgment over the weekend, and on the Monday she set out in her judgment all of the matters that she was going to admit in our favour to support our client of the content of the evidence of the other two employees to give credibility to our client. And that's in a judgment of the federal court. You can go and look at it. And it was at that point that the employer decided that he wouldn't go any further, and the case settled. So that was very unusual, but very exciting and very gratifying process, because it meant that we had a number of other witnesses to call. The case would have gone on for at least another 10 days if we had to pursue it any further, and we were able to settle it on very good terms, obviously, for my client. I can't obviously say what, but good terms for my client and most satisfied. So that was one of the highlights of my career.